When, where, and why. Application of non-UCC rules and law. Presented by the American Bar Association Solo, Small Firm and General Practice Division, Section of Administrative Law and Regulatory Practice, Business Law Section and Center for Professional Development. American Bar Association Center for Professional Development, 321 North Clark Street, Suite 1900, Chicago, IL 60654 7598 www.americanbar.org 800.285.2221. The materials contained herein represent the opinions of the authors and editors and should not be construed to be the action of the American Bar Association Solo, Small Firm and General Practice Division, Section of Administrative Law and Regulatory Practice, Business Law Section or Center for Professional Development unless adopted pursuant to the bylaws of the association. Nothing contained in this book is to be considered as the rendering of legal advice for specific cases, and readers are responsible for obtaining such advice from their own legal counsel. This book and any forms and agreements herein are intended for educational and informational purposes only. Copyright 2016 American Bar Association. All rights reserved. This publication accompanies the audio program entitled, When, Where, and Why. Application of Non-UCC Rules and Law. Broadcast on July 26, 2016. Event Code CE1607 UCC. Submit a question. Visit https://americanbar.qualtrics.com/say/ SID equals SV_2UB91-6FL and P code equals CE1607 UCC to submit a question on the content of this course to program faculty. We'll route your question to a faculty member or qualified commentator in 2 business days. 1. Non-UCC rules in UCC cases. Steve Weiss Proskauer Rose LLP. 2. Outline. General relevance of non-UCC law, agency, choice of law, contract interpretation, contract amendment, contract novation, mistaken reformation, void contracts and standing, indemnity, good faith, subrogation. Tracing, trust law, fiduciary duties, fraudulent transfers, property, trust law, remedies, liquidated damages, guarantees, forbearance agreements, arbitration, successor liability. 3. UCC reference to other law. UCC Section 1 to 103, b unless displaced by the particular provisions of the Uniform Commercial Code, the principles of law and equity, including the law merchant and the law relative to capacity to contract, principal and agent, estoppel, fraud, misrepresentation, duress, coercion, mistake, bankruptcy, and other validating or invalidating cause supplement its provisions. 4. Federal common law. There is no federal common law, O. Claxon, except when there is O. Casa del Cafe Vergnanospa no arbitration agreement for FAA. 5. Common law. Agency. UCC Section 9 to 509. Filing is effective if authorized. Comment 3. Generally look to other law to determine if authorization exists. 6. Common law. Agency. Official Committee of Unsecured Creditors of Motors Liquidation Company v. J.P. Morgan Chase Bank, N.A., 103A3D 1010, Del. Sup. Court 2014. The Second Circuit has asked us to assume that the secured party itself, J.P. Morgan, review ed. and knowingly approved for filing a UCC-3 purporting to extinguish the perfected security interest. For a termination statement to become effective under Section 9 to 509 and thus to have the effect specified in Section 9 to 513 of the Delaware UCC, it is enough that the secured party authorizes the filing to be made. Emphasis in original. Official Committee of Unsecured Creditors of Motors Liquidation Company v. J.P. Morgan Chase Bank, N.A., 777 F3D 100, 2nd CIR. 2015. From these facts it is clear that although J.P. Morgan never intended to terminate the main term loan UCC-1, it authorized the filing of a UCC-3 termination statement that had that effect. Actual authority is created by a principal's manifestation to an agent that as reasonably understood by the agent, expresses the principal's assent that the agent take action on the principal's behalf. 7. Common Law Agency. In Re the Adoni Group, Inc., 2015 WL 2080521 Banker. SDNY. 2015 Debtor can ratify earlier, unauthorized filing of a financing statement. 8. Common Law Agency. Cantor v. FDIC in Re Downey Financial Corporation, 593 FAP. 123 3DCIR. 2015 Tax sharing agreement did not create agency relationship because alleged principal did not control alleged agent, thus property in possession of agent was agent's property. 9. Choice of Law UCC Section 1 to 301. In Re Nelson, 521 BR. 733 Banker. DSC. 2014 enforces Choice of Law Clause, which gives secured party greater rights. Trustco Bank v. Matthews. 2015 WL 295373 Del. CH 2015 Court determines that place of harm determines law applicable to a fraudulent transfer. 10. Common Law Contract Interpretation. U.S. Bank N.A.V. Yashoafar. 232 Cal. App. 4th 639 Cal. App. 2014 No prepayment fee due until defendants actually prepaid the note's indebtedness. In Re Energy Futures Holding Company, 539 BR. 723 Banker. D. Del. October 29, 2015 Makuhol Premium Provision interpreted not to apply as a matter of contract law as a result of filing of bankruptcy. 11. Common Law Contract Amendment. In Re Residential Capital, LLC, 2015 WL 2226232 Banker. SDNY 2015 Depositary Bank may use change of terms provision to make depositor into guarantor of debts of affiliates if depositor owed to bank. 12. Contract Novation. Restatement 2nd of Contracts 280. A novation is a substituted contract that includes as a party one who was neither the obliger nor the obligee of the original duty. Inwood Natal Bank v. Wells Fargo Tex App 2015 Renewal of note is not a novation, and therefore not a future advance, for purposes of UCC Section 9 to 323. Standard Bank vs. Hughes Ill. App 2015 New note that was in exact amount of sum of two earlier notes was novation, for purposes of determining application of guarantee. 13. How to count. Legras vs. Aetna Life Insurance Company, 786 F3D 1233 9th CIR. 2015 As a matter of federal common law, when counting days within which an act must occur, if the last day falls on a weekend. 14. Mistake and Reformation. Charles R. Tips Family Trust v. PB Commercial LLC, 2014 WL 4085496, Court App Texas 2014, note that misstated in words the amount loaned could not be reformed because of pleading error. In Re Duckworth, 776 F3D 453, 7th CIR 2014, security agreement that misstated date of secured note by 2 days could not be reformed to refer to correct note. 15. Set off. Santander Bank, NAV. Durham Commercial Capital Corp. Underscore F sub.3D underscore, 2016 WL 199408 D Mass. 2016 Breach of Confidentiality Provision and Recoupment Rights. 16. Notes and Mortgages. Aurora Loan Services, LLC v. Taylor, 2015 WL 3616293 NY June 11, 2015. As a matter of common law, not UCC Articles 3 and 9, the person in possession of a note has the right to enforce it and the related mortgage follows the note. 17. Void Contracts and Standing. Ivanova v. New Century Mortgage, 62 Cal. 4th 919, February 18, 2016, maker of note has standing to assert that transfer by payee was void. 18. Indemnity. La Medier Beauty Investment Partners LLC v. Medier Tribeca, LLC, NYLJ 1202719289123, Sup. Court App Div. 2015 Enforceability of Defective Non-Reliance Clause evaluated as a general disclaimer. 19. Subrogation. Perlman v. Reliance Insurance Company, 83S Court 232, 1962, Subrogation Rights of Surety. Cantor v. Schlager, 358 Mass. 789, 1971, Subrogation Rights of Surety. 20. Subrogation. Avondale Gateway Center Entitlement, LLC vs. National Bank of Arizona, 2011 WL1376997 D. Aries. 2011 Contractual subrogation can operate more broadly than equitable subrogation. 21. Tracing. Universal CIT Credit Corp. v. Farmers Bank of Portageville, 358 F. Sup. 317 EDMO 1973, Rules of Constructive Trust Law used to try to trace proceeds. 22. Tracing. In Re. Tusa Expo Holdings, Incorporated, 811 F3D 786, 5th CIR. 2016, bankruptcy trustee has the burden of tracing on preference claim even though the comments to UCC Section 9 to 315 suggest that the burden is on the secured party. 23. Fiduciary duties. Ferris CV. The Livery, LLC, 232 Cal. App. 4th 419, 2014, perfected secured party did not have priority over unperfected secured party because perfected secured party owed a fiduciary duty to unperfected secured party and acted unfairly. Fiduciary duty arose outside of the Article 9 relationship. Iqbal v. Zafar, 2013 U.S. Dist Lexus 146393 ND. IL. 2013, lender does not owe fiduciary duty to borrower in workout. Jolly v. Chase Home Finance, 213 Cal. App. 4th 872, 2013, lender may have fiduciary duty to borrower. 24. Fraudulent transfers plus equitable subordination. Sentinel Management Group, Inc., 2016 WL 98601, 7th CIR. January 8, 2016, in defense of actual intent, fraudulent transfer action, transferee may assert good faith defense under Bankruptcy Code Section 548C. To use that defense, transferee must make diligent investigation when it becomes aware of suspicious facts relating to the legitimacy of a loan transaction. The transferee must be on inquiry notice, which required it to investigate the collateral the borrower was using to secure the loan where the transferee had awareness of suspicious facts that would have led a reasonable firm, acting diligently, to investigate further and by doing so discover wrongdoing, and an investigation would have revealed that the bank could not in good faith accept assets of transferors' customers as security for the bank's loans to Sentinel. These facts did not also justify equitable subordination, unless they amounted to fraud. That standard would require that the bank believed there was a high probability of fraud and acted deliberately to avoid confirming its suspicion. The secured party's suspicion of potential wrongdoing without any follow-up might be negligent, but that is not an adequate basis for imposing equitable subordination. 25. What is property? In Ray Circle 10 Restaurant, LLC, 519 BR. 95 Banker. DNJ 2014, liquor license and its proceeds are not property for purposes of Article 9. 26. Trust law. Who has the interest in the property? UCC Section 9 to 301. 1. Except as otherwise provided in this section, while a debtor is located in a jurisdiction, the local law of that jurisdiction governs perfection, the effect of perfection or non-perfection, and the priority of a security interest in collateral. UCC Section 9 to 102, a 28 debtor, means a person having an interest, other than a security interest or other lien, in the collateral, whether or not the person is an obliger. Restatement 3rd, of trusts. Section 3. 3. The person who holds property in trust is the trustee. Section 42. The trustee takes a non-beneficial interest of unlimited duration in the trust property. 27. Escrows, who has the interest in the property. Wakefield Kennedy, LLC v. Baldwin, 2014 WL 910029D. Utah 2014, affirmed 2015 U.S. App. Lexus 9739, 10th CIR. 2015, debtor no longer had rights in the note placed into escrow. 28. Liquidated damages. Malum v. Adobe Systems Incorporated, 2015 WL 124663 ND. Caliph, 2015, early termination fee is not liquidated damages, and thus not analyzed to determine if it's a penalty. 29. Remedies. Harris v. TD Ameritrade, Inc., 805 F3D 664, 6th CIR. 2015, entitlement holder does not have private remedy for securities intermediaries' breach of obligations under UCC Sections 8 to 504, 8 to 506, 8 to 507, and 8 to 508. O decision does not refer to UCC Section 1 to 305b. Any right or obligation declared by the UCC is enforceable by action unless the provision declaring it specifies a different and limited effect. 30. Guarantees. California Bank and Trust v. Del Ponte, 232 Cal. App. 4th 162, 2014. Guarantor waivers must be specific. Cooperative Central Raiffeisen-Borenleenbank, BAV. Navarro, 978 NYS 2D 186 NY Sup. Court App. Div. 2014. Guarantor waivers may be broadly stated. 31. Unconscionability. Grand Prospect Partners, LPV. Ross Dress for Less, Inc., 232 Cal. App. 4th 1332, 2015. No procedural unconscionability where party refuses to negotiate with respect to a particular term. 32. Forbearance Agreements. Arias v. Elite Mortgage Group, 108A3D21, NJ Sup. Court App. Div. 2015. Lender does not breach duty of good faith when terminating loan forbearance agreement when borrower defaults. In Re TPOP, LLC, _BR, banker, D. Dell, 2015. Creditor does not have to forgive debt when debtor breaches forgiveness agreement. 33. Arbitration. Lexel Imaging Systems, Inc. v. Video Display Corp., 2015 WL 403140 EDKY 2015. Scope of arbitration clause does not require arbitration to determine if default exists before secured party exercises self-help. 34. Successor liability. Automotive Innovations v. J.P. Morgan Chase Bank, 2014 WL 77457773 NJ. Super. App. Div. 2014. Article 9 foreclosure sale does not insulate buyer from successor liability claim. TAP Holdings, LLC v. Oryx Finance Corp., 970 NYS 2D 178 NY Sup. Court 2015. Buyer from foreclosure sale. Buyer has successor liability, where, essentially, the same entity